Hello and good afternoon. Thank you for joining us for our final webinar of 2019, the U.S. State of Immigration in 2019 and look ahead to 2020. We have a great presentation ahead, but before we get there, just want to go over a few housekeeping items. First off, this webinar is being recorded and everyone in attendance will receive a link to download the recording. You will also receive a link to download the slide deck, as well as SHRM and HRCI continuing education credits. All of these materials will arrive in your email inboxes tomorrow afternoon, so please keep an eye out for that message. If you don't receive it, please let us know and we'll be sure to send it over your way. Additionally, this presentation includes an audience question and answer session. If you have a question throughout the presentation, please type it in. You should see a chat feature from GoToWebinar on your computer screen. Type that question in and we will try to get to it at the very end. Please keep in mind, however, we cannot answer any case-specific questions. Please consult with your immigration attorneys for those. So, moving along, for those unfamiliar with Envoy, for nearly 20 years, Envoy has been on a mission to fix the inefficient, confusing, and frustrating immigration process. Envoy combines expert legal representation with innovative technology to deliver the only platform that makes it seamless for companies to hire, mobilize, and manage a global workforce. Envoy secures work authorization in over 150 countries, has grown 41% year over year, and works with over 1,000 customers. Envoy is particularly proud of their NPS score, which is a testament to the employee experience we provide. And introducing today's main presenter, we're joined today by Sarah Herbeck, the managing partner at Global Immigration Associates, where she and her team of experienced lawyers provide strategic immigration advice regarding the movements of professionals throughout the world. In her role as managing partner, Sarah oversees over 80 attorneys, paralegals, and support staff. Sarah, thank you so much for joining us this afternoon.
Thanks, Eric. Happy to be here.
So, as I mentioned, we have a great presentation ahead. A couple more slides to go over. Not too much in terms of an agenda. We've got 3 different sections here, looking at 2019, then looking ahead to 2020, and then some practice pointers for 2020. And then just a quick disclaimer slide that I will leave up for a couple more seconds. And with that, let's examine the state of immigration in 2019. So Sarah, the first slide that we have here are just some headlines that we grabbed from the last couple of months indicating U.S. CIS continued to maintain higher levels of scrutiny in 2019. I remember about a year ago at this point, we were looking at 2019. This was one year you mentioned things weren't going to change.
Yeah, I think last year we had predicted, unfortunately, glass is half not full, that we would expect the trends that we saw in 2018 to continue again in 2019, and we saw just that. Mm-hmm. Obviously, I don't have a crystal ball, but if the past couple of years have told us anything, skipping ahead to our 2020 forecast, I would expect to see pretty much the same thing. I think what you're going to show in the next couple of slides is that it got slightly worse. Mm-hmm. Not a lot, but when you're looking at the fact that we made a pretty big leap from 2017 to 2018 from a scrutiny level,
right.
All of the information coming out of USCIS regarding there is a lot of discretionary authority with USCIS officers, we're seeing that. Mm-hmm. So while that may not have been public information a year ago, it makes sense. And right now, we're just kind of connecting those dots with the release of public information.
Right, and some of that public information really just helps us illustrate that the higher levels of scrutiny. So here we're looking at RFE rates for the H-1B petitions. So I have a 2-part question for you here. So the first one is, what's a request for evidence? And I guess why is that like an indicator of scrutiny?
Okay, so what happens is, generally speaking, you file an H-1B, since we're looking at H-1B numbers, I'll use H-1B specifically. When you file an H-1B with USCIS or any non-immigrant petition, you submit it with evidence to support the attestations that you make throughout the petition. So to support the facts that you've asserted in the forms and also in the letter of support and any documentation along those lines. And you submit that with the intention that you will then receive an approval. I think everybody's goal when filing a petition is approval.
Get that approval, yeah.
Right. What a request for evidence is, or RFE, it's basically USCIS saying, thank you so much for submitting the information. I'm being polite here, but we don't believe that you've met your burden. From a burden standpoint, it's a probability standpoint. I'm going to go a little nerdy here for immigration moment. It's more likely than not. We're not at the criminal law standard. We are 51% accuracy. You should be approved. And what we're seeing is, despite this burden of proof, despite the evidence that we would traditionally and as a requirement submit, the historical adjudication standards and practices, the legal adjudication standards and practices, and what I mean by that are engineers. Engineers are specialty occupations, and we're seeing pushback from USCIS on that. Level 1, entry-level positions, we're seeing pushback on that. There's no such legal requirement that you have to have an experienced position, be an H-1B specialty occupation. The straightforward, very simplified overview, but is still in fact and in law true. To be a specialty occupation to qualify for an H-1B, you need to have a position that requires a bachelor's degree in a specific field or related fields, and the individual must have that bachelor's degree or its equivalent in the field or a related field. Again, I know I'm oversimplifying it, but those are the nuts and bolts.
Right.
We're seeing increased, obviously, through the lovely data that you've compiled here. Maybe not lovely, but through the data.
Yeah, through the data.
Very telling.
Right. And so the first one here, seeing the H-1B petitions with an RFE, it's approximately 40% receive an RFE, and then the approval rate of H-1B petitions with an RFE is just over 60%. So just quick question, what's the difference between the chart on the left and the chart on the right?
Sure. The chart on the left is the request for evidence. So these have been submitted to USCIS, and they've been asked for additional information. And you'll note that it's almost doubled since 2017.
Yep.
My math's not perfect, but the chart looks about like that. On the right-hand side is the approval rate of H-1Bs. That has obviously gone down with the increase of request for evidence. Certainly, there is a situation where you can get an H-1B approval without getting a request for evidence. If a request for evidence is issued, you're going to see that higher scrutiny, and there's a stronger likelihood of a denial.
Gotcha.
And that is definitely when you need to speak to your immigration attorney.
For sure. And interesting, maybe not, but it's not just the H-1B that's facing higher scrutiny. Another employment-based visa experiencing higher scrutiny is the L-1A and L-1B. Again, the data is publicly available. So what do the higher RFE rates for the L visas indicate, and I guess why are they also being placed under high scrutiny?
Right. So these, again, L1s, for just a little quick summary of what the L1 is. An L1 is an intercompany transferee visa where you've got to prove historic employment with an entity abroad. And for a multinational executive or specialized knowledge occupation. L-1Bs, I would say, generally have been under scrutiny, not only at USCIS, but also at U.S. consulates for a bit. But they are one of the more highly scrutinized non-immigrant visa categories. So that scrutiny isn't super shocking. But I still think that it is indicative with the increased request for evidence rate that you're looking at, and certain filing requirements for extensions having to be filed with USCIS versus Canadians at the border, which generally is a faster, cheaper adjudication process for those individuals who have Canadian citizenship. You're looking at that trend being not quite the same, but similar to the H-1B. And I would, if they were actually to strip out the data, if they could, and really look at L1A, L1B, my hopefully accurate guess would be that the high rates of RFEs there's probably more L1Bs. Or if you look at the total number of L1Bs filed versus the total number of L1As filed, the L1B RFE rate would be higher.
I see.
That would be my estimation.
Gotcha. Yeah, because they don't,
based on experience. They don't strip them out.
Right. Yeah, because and they don't differentiate with the data that's available here. They just put it on.
Right. It's just an L1.
Right.
And so it would be interesting to see if they did flesh that out so that we could understand it. But I would, based on generalized scrutiny that we've seen, particularly for the L1B for a long time, for those to be still either those have spiked, and then L1As kind of followed suit. Or those are the vast majority of ones, like ratio speaking. For approval rates, you see that they are kind of up, down, but they're not as high.
Right. Yeah.
50%. I mean, that's a lot. You're looking at individuals where companies have made at least 1 year they've invested in them for at least 1 year of working abroad at a foreign entity or foreign-related entity, and they've made a business decision to bring those individuals over for very specific reasons. And so while the H-1B denial numbers, or I guess, let me speak positively, approval numbers are shocking, you're also looking at companies who have very specifically taken the time to identify key individuals to bring over to the United States and still being told no.
Right.
Which I think it's always frustrating to receive a denial, but I can imagine after investments in trainings abroad, or even work abroad, or contributions abroad, having a known individual come in, it can be just as frustrating as H-1Bs. For sure.
So yeah, again, this is just a snapshot of the scrutiny, and when all of our attendees receive this slide deck, that link at the bottom on this slide and the last slide will be clickable, so you can dive even deeper into the data that USCIS put out. You can even see RFE rates for the O visas, the P visas, and everything.
The alphabet soup.
There you go. So moving along, we've highlighted a couple of notable policy updates that came out this year. So the first one that we want to look at is the social media policy. This came out in about the summertime this year. So I guess what is the social media policy?
Right. So ultimately, at the end of the day, what U.S. Consulates are requiring is that the foreign nationals who are applying for visas at U.S. consulates or embassies abroad, I should include embassies in that also counts, are required to provide their social media history and ensure that it is a part of their, or will be providing that information. I would likely guess, as you've noted below, that it will probably be expanded. And I think what is just good food for thought here is this is publicly available for the most part information, right? You can privatize your Facebook account, you can privatize your Instagram account as much as possible, but you're putting yourself out there.
Right.
And so I think it's just good to be mindful, particularly when working with employees who are either going to go through the visa interview process or you're gearing them up to do so, is just, be aware that it's not just your friends who are potentially watching.
Right.
And that you have to be mindful of the voice and the persona that you have made publicly available, because a U.S. consular officer could take issue with certain stances and the like. Now, it's, in this situation, is it something that there's a specific law very much saying you're going to be inadmissible if you said negative things? Well, no, but that doesn't mean that there won't be pushback. There won't be a further investigation if negative topics against, say, the United States are made. They probably are going to pull that thread and dig a little bit deeper. And again, while I'm not going to limit anybody's freedom of speech here, that's not my job. It is just, again, I encourage you to speak to your employees, speak to your counsel regarding just being mindful of the, not only person that you know as a professional, right, on a day-to-day work basis, but also that person's digital footprint and what that looks like.
Yeah. And that includes the social media at virtually everything,
yes.
right?
Yes. And I think this was one of those items that, again, it's basically publicly available.
Yeah.
So that's why it was, I can imagine, hey, we need to look into this.
Mm-hmm.
What have people been saying?
Right. So this is one thing that we'll keep our eyes out on.
Mm-hmm.
For 2020, there it is, as you mentioned, expanding.
I would expect it to expand for sure.
Gotcha. And great. So then the next update centers around the H4 EAD.
Mm-hmm.
So big picture, what is the H4 EAD?
Right. So the H4 EAD is for spouses only of H-1B non-immigrants, where the H-1B spouse has, or through his or her employer,
mm-hmm.
has completed certain steps of the permanent residency process that then allows their spouse to file and receive work authorization.
Okay.
It's a great benefit. It's particularly notable for those individuals who are waiting a long time to receive a green card,
mm-hmm.
or even apply for a green card. So you're putting in position those individuals, you're kind of equalizing the playing field for spouses.
Gotcha.
And so it certainly, in my mind, is great in the economy. It's great for those individuals who are, you're a spouse and you're highly educated and you want to work. It's great to be able to have that opportunity.
So it has a great benefit on the economy, benefits families. Why is it under so much scrutiny then?
Because there are individuals who believe that there are certain H4 EAD workers that are taking their jobs away. Now, again, I'm not a mathematician, but I would look at the unemployment rate and the fact that it's so low, mm-hmm. and the H4 EAD exists. And to me, that would be, again, generally, not a data scientist, don't want to say this as a law or legal conclusion, but the idea is that you have these individuals in the U.S. workforce now, mm-hmm. and we're at the lowest unemployment rate. So to me, it makes it much harder to make the argument, mm-hmm. that they're impacting individuals' ability to get jobs.
Right.
Now, I know that there are individuals out there who would disagree, mm-hmm. and that's kind of where we find ourselves right now.
Mm-hmm.
And that is why I hope that the benefit is not rescinded. I would expect that if the benefit is rescinded, to see some lawsuits, kind of circa when DACA was initially going to go away. And, DACA is still here, so again, I'm going to go glasses half full here. Let's hope that the H4 EAD continues.
Right. If it were to be rescinded,
mm-hmm.
Any indications on when that might be?
Probably, they've announced March 2020 would be when we would expect an update. And it could be before, could be after. That's going to be smack dab in the middle of the H-1B cap season.
Mm-hmm.
However, USCIS has been making announcements, and quite a few of those as of late, so that doesn't mean that just because it's in the middle of cap that they'll hold off. It's a different visa category than an H-1B. It's just it's the derivative beneficiary visa classification, not the principal. So the spouse, not the worker.
Gotcha. Another thing we'll keep an eye out on in early Q1 of 2020.
Yes.
So the next policy update that we want to discuss. So in August, there was the update to the final rule on public charge
mm-hmm.
ground for inadmissibility.
Right.
So before diving into the rule,
mm-hmm.
can you explain what public charge is?
Sure. So part of what you need to be able to demonstrate when you file for your green card is that you're not going to become a public charge to the U.S. government, and that you can basically support yourself. They've set specific guidelines regarding the level of income based on family size that you would need to meet in order to overcome any indication to be a public charge. I think for those individuals who are listening to this webinar, more likely than not, or probably higher than that, this rule, whether or not it is ever implemented, will hopefully not impact your employees. But it is just a good food for thought item, something to think of when you're looking at adjudication standards. So the idea behind the way that this rule is going to be implemented was, I don't know if anybody's seen the movie Minority Report, but it was the idea that it gave the officers a lot of discretion to make the determination of, while there may not have been a history of being a public charge for that particular individual or green card applicant, if the officer felt as though this could happen, that could have had a negative impact on the green card application itself. And so even though there might not have been any evidence, it still could have been used against the applicant, him or herself. And so that had a lot, that discretion is one of the reasons why we find ourselves in a situation where judges have obviously blocked it.
Right, yeah.
As it clearly said, it was set to go in effect and it's been blocked. And that sort of simply stated is why we find ourselves in a situation where they're kind of having to go back to the drawing board. Much like, I believe, our next topic, the presidential proclamation.
Yep. This is also held up in the court.
Yep.
But so this was a proclamation, as you mentioned, from President Trump. It would have required immigrants to prove that they have health insurance or prove they can pay for medical care before they get visas, correct?
Correct. Yeah. So again, for those individuals coming to the United States applying for immigrant visas through their employment. So most of, again, our participants today are likely going to find themselves in the situation, so the proclamation may not have been as, the impact probably not as severe as, say, a family-based member. But again, it still goes into another layer of requirements that were not legally required, but just stated. And that kind of comes down to one of the reasons why it was stopped. And again, just ability to demonstrate health insurance. Even those, individuals who are coming over from an employment-based perspective, those individuals who are in the United States in non-immigrant status getting U.S. benefits, it's going to be very easy for them, right? Or theoretically, it should be easy for them to demonstrate that they either have health insurance in the United States or will have it, again, with employment-based. But what this is going to do is it has a very chilling impact on family-based matters, where your whole family might be moving to the United States, and sure, one of the steps you intend to take is obtaining insurance, but you could have a lot of money tied up in your move.
Yeah.
And so there's again, adding on additional financial burden to applicants that is not there, that is very similar to what they're trying to do with the public charge.
I see. Gotcha. And so this one obviously came from the executive branch. The other one came from USCIS, an agency. But now we're going to shift to Congress.
Yes.
And in October of 2019, a few senators introduced the Resolving Extended Limbo for Immigrant Employees and Families, otherwise known as the Relief Act.
And I will refer to it as the Relief Act.
The Relief Act.
As well.
Perfect. So this piece of legislation addresses green cards.
Right. Specifically, and I think probably for our audience, again, I think one of the biggest takeaways for me is the second bullet point on this slide right now. I, personally, and as an immigration advocate and attorney, I think it's great, this proposal. I think the idea of maybe not necessarily increasing visa numbers, that can be a little controversial,
right.
But how they're adjudicated and how you look at immigrant visa allocation this is a great compromise. You're treating, so what happens now is if in an employment-based immigrant visa situation, the green card applicant has, in addition to him or herself, including him or herself, I should say, 5 family members total. That would mean that 5 immigrant visas would be taken away from the overall pool that is released every fiscal year, so October 1st. Or October 1st of every year is when visas are released, I should say. What this would actually do is only one immigrant visa would be allotted, and all of the family members would be treated as derivatives or as immediate relatives of that immigrant visa holder. So instead of using 5, you use 1.
I see.
And okay. I think it's a great way of helping push forward long wait times green card applications, and in a very realistic and practical way.
why? So speaking of the green cards,
Sure.
so why is Congress seeking to reform the green cards? Because this is and I'm going to move to the next slide because it still deals with the Relief Act. So this is the Senate version. Then back over the summer, the House passed their Fairness for High-Skilled Immigration Act, and that was passed in bipartisan manner. So I guess my question is, why is Congress seeking to reform the green card?
Why, right? It's long wait times. So the way that they have immigrant visas, and I'll speak specifically, it's very similar to family-based, but I'll speak specifically to employment-based. They have a certain number of visas that are immigrant visas that are issued every year. Then those are broken out by country of birth and then by immigrant visa category. So you have from your employment-based first preference all the way down.
Right.
Most of the individuals on this call, you're likely looking at employment-based first, second, and third preference for your employees. Those categories are broken down, allotted a certain number of visas, and then by country of birth again. And those individuals who are born in India or China are looking at very long wait times, exceptionally long wait times. And what the intent here, in my mind, is to try and even out the playing field. Try to make sure that, if you're born in India, you're not waiting 10, 15 years for a green card.
Oh, it could be that long?
Yeah, 10 about, but I'm over-exaggerating to prove the point.
Right.
Whereas somebody born in, say, England could potentially have a green card based on processing times in like 2 years once filed. Probably less, probably about a year, but with the new process that was implemented of interviewing every single adjustment applicant, processing times are not as quick as they used to be for employment-based. So you always want to err on the side of this could take longer than we expect. But yeah, I think the Relief Act is great in the way that it wants to treat family members.
I see.
I think when I look at everything, that's sort of the most straightforward item that they've talked about in my mind. That just makes such good sense.
Yeah.
In my opinion.
In your opinion, yes, for sure. We'll definitely see where these two pieces of legislation head to. Obviously, there are bigger things happening in Congress.
Yes, there are. Yes.
So we'll keep an eye out on these two pieces and what happens there. So that is going to bring us to the hot topic of the month, electronic registration. Finally, on December 6th, USCIS announced that it will implement electronic registration for the upcoming CAP season, aka fiscal year 2021 H-1B CAP season. So this comes after many months of speculation. Right. Will they, won't they?
Yep.
So based on what's been released so far, can you discuss what electronic registration is?
Sure, what we know about it.
What we know about it, yeah.
And the fact that we're still waiting for further guidance, which will hopefully come out sooner than later, since I can imagine that most individuals on this call have either finalized their list for individuals they want to sponsor for the CAP, are starting to open up H-1B CAP cases, or are very close to doing that thing. So the first and foremost is that, yes, USCIS has announced that it will be electronic registration, and electronic registration will be open effective March 1st and will run through March 20th. And that registration will include a $10 registration fee. Regarding how you're notified for selection, when you will specifically be notified for selection, and how long you'll have to submit the H-1B petition if selected in the CAP, that's a little, we're waiting for the guidance on that. I guess, when you just look at dates and kind of pull it back from there. So you have the registration from March 1st to March 20th. We're going to go ahead and assume that it will be, they'll have some sort of time frame cutoff, maybe midnight Pacific in the United States, that they'll cut it off on March 20th. Theoretically, because it's all electronic, you would think that the random lottery would necessarily begin.
Right.
And, in theory, we would have notifications beginning March 21st. That's super aggressive, but, stranger things have happened, and it could be that quickly. I wouldn't hold my breath for that level of responsiveness, but theoretically, yes.
Yeah.
I would expect it to take a couple of days, maybe a week, maybe longer, to start receiving those electronic notifications. How? Probably by email. Maybe you have to log into your account. Again, the nuts and bolts of that are to be determined.
Right.
I would expect that because of the way filing works, where you're supposed to file new petitions or extensions 6 months in advance of when you want that benefit. And that's sort of the guideline rule out of USCIS. So if you expire in July of 2020 and you're filing a basic extension for an H-1B, you're not actually able to, even if you're ready to go today, you're not able to file it for another month. It has to be 6 months out. So I would expect that even if somebody is notified before April 1st, if they've been selected, or an employer has been notified that a specific individual that they want to sponsor has been selected, we're probably looking at not being able to file, and they'll be given, say, a time frame of April 1st to June 30th, something along those lines.
Okay.
We don't expect an immediate filing timeline. We don't expect to be told you have to file this in 5 business days or the first 5 business days of April. That's not what is expected. That's not what the guidance hints toward, but we don't have the specifics.
Right. There's still a lot of info that needs to be released.
Right. And these are more, I think probably the most important announcement that USCIS wanted to make was the fact that they were going forward.
Yeah.
I think that one of the, when speaking to Immigration Counsel as to how you want to proceed, I think there are some pretty important food for thought items that need to be on everybody's plate. How does Immigration Counsel feel about, the registration itself? It's a brand new process. It's been tested in a test environment. It has not actually been practically tested. If I just want to register, what are my risks?
Right.
If I want to mitigate risk, what steps can I take? What are those recommendations? And I think that, hopefully HR, talent acquisition, individuals who manage immigration functions within companies will come up with a good plan. I think a secondary question, then, just because, it never ends
questions,
never ends with lawyers, is also sort of what is a company's take on, do you want to make sure that every single H-1B cap registration is the process that is followed is the same for every employee? Will you make exceptions? I think that is where you're really going to want to get into the nuts and bolts. So, for example, one of the individuals that I've been talking to, they definitely want assistance in preparing and filing the registration, conducting an analysis to determine, does it look like the H-1B or the position being offered meets H-1B legal requirements? Does the individual, him or herself, qualify? Or will they qualify? Do we have the right wage? And once they actually proceed with filing a labor condition application in addition to registration. That's just what they've decided to do, it's what the company feels comfortable doing at this point in time. Fantastic, great, we can help with that. And then the subsequent question is, well, do you want to make sure to do that for every employee? You might have employees in different circumstances, like maybe somebody's on an L.
Right.
Or somebody's on a TN. So they already have backup work authorization. So the H is just a strategic decision that's being made, not a necessity for ongoing work authorization. For individuals who are in F1 status, who are graduating and potentially have already used up not only their EAD time, but their 2-year STEM extension on EAD and need this H-1B to be selected to be eligible to continue working in the United States, also known as cap gap, whereby their EAD expires after April 1st, but before October 1st. And that, do you want to treat everybody differently? I think that is really a personality. Like, how does a company want to proceed forward? Also balancing out legal requirements. So there are a lot of factors to take into consideration. It's nuanced, but there's also a lot of unknown.
Right.
And I think one of the factors to also take into consideration is USCIS's own statement that at any point in time
they may roll back.
Correct. And so, there are a lot of factors to take into consideration. And so it's well worth doing a very deep dive with your immigration attorneys to really understand where you're going to feel comfortable. how you want to message that to your employees, how you want to support your employees through this process, because the entire process has been turned upside down.
Yeah.
And it's a whole new world. So
whole new world.
Here we go. H-1B cap, like I've never seen them before, and I won't tell you how many I've seen.
You took away one of my questions. But just really quick, we do have a webinar set up in the middle of January. When you receive the slide deck tomorrow, if you take a look at your screen, when you receive the slide deck in PDF format, you'll be able to click that and you can sign up for that webinar. Ann Walsh, managing attorney, will be discussing electronic registration on that in further detail. So that's going to lead us into looking ahead to 2020.
Yep.
Well, obviously, one of the things you just discussed in great detail was electronic registration. But what else are you keeping an eye out for next year or on the horizon?
Right. I think we're still going to continue to monitor scrutiny levels, RFE rates, approval rates, and the like. We will continue to look at green card processing timeframes. So you say reform, but I also look at processing. From the filing, if you can actually receive a green card and you're not waiting for it, the way that you file, you can actually receive a green card. How long is it actually taking? What are the interviews looking like? We spend a lot of time speaking to our clients' employees, just preparing them for the formalized interview process at USCIS. Most individuals that we talk to have been to a U.S. consulate to get a visa or anything along those lines. But there's obviously another level of, this is a green card, right? This is a very big deal. This is to become a lawful permanent resident of the United States, to get a lot of benefits that become of that, and even potentially start, have your start date for becoming eligible for citizenship, right?
Yeah.
So, which it's a very big deal. And, if you want to be able to vote, like U.S. citizens or most U.S. citizens are going to be able to do in 2020, it's a very big deal for foreign nationals. And so while we've seen individuals be sort of, I've got this, I've been there before, I think kind of when the reality sets in. So reform or not, asking for information on forms, asking for more money for green cards, which USCIS may do across the board for filing fees, increase in some areas, decrease in others. To me, I would expect the continued scrutiny to actually very much connect to the green card reform and see continued scrutiny and adjudications from a non-immigrant perspective, but also diving deeper into the foreign nationals. The way that DUIs are handled that's been turned on its head as of late. And so employees are, we have to be very mindful. So it's also exceptionally important, as a reminder, as it would always be, being truthful and upfront with employees for questionnaires and getting the information so that we don't find ourselves in a situation where we have to backtrack.
Okay.
Particularly when it comes to reform.
Yeah.
Regarding the 2020 election, now that we are almost in 2020, and that's a whole other topic.
Yeah, a whole other topic. Yeah.
December 18th today.
Speaking of 2020, when a lot of candidates discuss immigration, but that's not employment-based immigration, which is what a lot of us on the call are, in. So do you think what role, if any, might employment-based immigration play in the election?
I think it'll be important. I think that companies are particularly interested in, at the very least, maintaining the status quo. I think ideally there are a lot of companies out there would be in full support of increasing H-1B visa numbers, but it's hopefully not getting more increase, not increasing the scrutiny to the extent where it becomes nearly impossible to get something approved, even though, from all the facts that you have, it shouldn't be. That's where I would think the general trend is. I do think there are some larger companies who are going to be very vocal about the importance of foreign national workers in the United States. I think they're going to be very vocal about the fact that our foreign student population has diminished and what that can potentially do to the economy, and what that can do to innovation. quite frankly,
Right.
and talent. Like, we don't want individuals to be educated outside the United States. We want to have them educated here, that are, particularly in the STEM degree fields, because those are innovators. Those are individuals who can really have or at least have the potential of being huge contributors to the United States economy. And so I would venture to guess the focus would be on that. Do I think Congress will kind of shake up the system, make huge changes in the upcoming election year? Probably not. We don't generally see a lot of movement, so I don't think I'm saying anything shocking.
Yeah.
But there are proposals out there that could change things. So it's just being mindful of monitoring them so that, if something does arise, you kind of know what's going on in the background to understand how it's going to be implemented.
For sure. Awesome. Now let's just briefly, I know we're running almost against the allotted time. So just some quick practice pointers for 2020, as we like to call them. So plan for the unexpected.
I'm fairly confident this was the slide that we had last year.
Yes. Not much. Yeah.
Not much has changed there. So I think that there are, making sure that you are, you understand that in this day and age, there are ebbs and flows, and there can be frustrations because you felt as though you've done everything to support your petitions, yet you're in a situation where you receive a request for evidence or a denial, and what do you do now? So I think that understanding the environment is exceptionally important. I think probably everybody on this call understands the environment, has dealt with the environment, at times is frustrated with the environment, but it's just, it, what to expect for, make sure that you're communicating with counsel, you're educating or asking for education, not only for yourself, but for the individuals that you support as needed, so that everybody can be in the know and understand that the more information, the better at this point in time, because we aren't the adjudicators as immigration attorneys. As much as we'd like to be able to be the ones making the decisions, we don't. So just, again, making sure that you're becoming aware, understanding who does what. So as we note here, site visits, as is mentioned, making sure you have your complaints, your public access files for H-1B, your perm audit files for your perms. Are they electronically stored? Where are they stored? Are they paper stored? Where are they stored? If a USCIS officer comes to visit, what's the chain of communication for that to make sure that if you are the individual that has been identified as the person who will manage that, you're contacted and you don't randomly have a USCIS officer walking around your company or just kind of walking to your desk. We don't want this. You want to make sure to have control and process in place. So again, this obvious plan for the unexpected, this slide wasn't unexpected. I think it's a repeat of last year, but it just reinforces what is important.
Right. And then, obviously, as you mentioned, just HR teams, particularly, stay up to date. Do you have any favorite sources, like news sources that kind of can provide some insights and reporting on things that are happening, whether it's in Washington or I don't know, anywhere else?
Right. I mean, I think the reputable sources that are mentioned on the slide, AILA is such a go-to for us, and we utilize that as a source. We also, we communicate within our own community, and as you said, benchmark with other corporations. I think that a lot of my clients have also reached out to their peers within their industries to find out what they're doing for CAP as a very specific and relevant example. And just understanding that, this is, again, highly scrutinized environment that we're working with, but there are ways to be strategic. It's just making sure that you've got that open communication and that you can understand how you as a voice for your company and your company wants to take next steps forward. So very, very, again, similar to last year. So we're prepared. We've been, we have gone through 2018, 2019. I would expect 2020, but for the revolutionary H-1B CAP registration, to be very similar in terms of what we've seen. So at least there's that.
Yeah.
So if that's a positive note, then there we go.
Awesome. Well, it's going to bring us to our Q&A session. But obviously, thank you so much for walking us through the looking at 2019 and some what may lie ahead in 2020.
Right.
So for 2020, obviously, I also do want to be mindful of the time. Does USCIS plan to walk users through the new electronic registration system?
Yeah, they'll provide. They're going to be providing guidance. They've given some screenshots. You're going to be able to look to see what's going on.
Okay.
But it's again, just be mindful that just patience, I think, is going to be a virtue during the electronic registration process.
Mm-hmm.
So just educating yourself, working with your attorney, understanding the level of support that you as a company would like to have during the process. So that's always good food for thought.
Gotcha. Have you seen the
I've seen screenshots.
Okay.
Yeah. I saw it. So it is very basic. It's not super detailed, right?
Mm-hmm.
The information that they're requesting is not, it's actually very limited in the grand scheme of things. Very, limited company information and limited foreign national information. But this is certainly a situation where, yes, biographic information is going to be filed electronically for foreign nationals. And so that's something that, I know that from a GDPR perspective, companies may want to talk about with their employees about what will be being done and how that works. But I'm going to go ahead and potentially make an accurate assumption that foreign nationals who are interested in CAP are watching this very, very closely.
Definitely.
So, yeah.
So on the topic of electronic registration as well, a couple people have asked this question. Is the CAP petition order selection process affected by electronic registration?
It'll be kind of flipped on its head like it was last year, so it'll remain consistent with last year.
Gotcha.
And so it is regular CAP, then master's CAP, versus master's CAP, then regular CAP, as it was in the past.
Right.
So.
Gotcha. Thank you. And final question. I realize we're going a little bit over time here. So, question for you, Sarah, is if you could recap the 2010s in immigration, how would you do so?
Recap the
from 2010 to 2019.
Ooh. Quick summary. I think that there has been a pretty significant change in adjudication and processes from 2010 to 2019. I think that there is, a more in-depth look at the foreign national. The immigration process is exceptionally intrusive for fair enough reasons. I'm certainly not gonna debate those. I get the underlying reasons for that, and appreciate that. And we're looking at that just expanding, so that there might be more process. There's going to be more scrutiny than we've seen in the past, and I think that it's just, sort of hits home that to support your programs, you being supported as well is critically important.
Yeah.
So I would have always said, make sure that you have support to a client contact or to a client, and said, look, you've got to have support too. I think that now, where there may have been less involvement in the past, C-level executives are very interested in immigration. And I can tell you, 9 years ago, that was not the case in my experience. So, given that level of visibility, that individuals who probably are wearing multiple hats when it comes to immigration, you make sure you get the support that you need to. We've talked about how we're going to support employees, how we're going to support our clients and companies, et cetera. For those individuals who are in charge, make sure you get the support too. That would be my big recommendation, and sort of the huge change where it's it's very important to get that support. Not that it wasn't always there, but I think
it's more
it's really critical.
So then the second part of that question is, and I know obviously during today's presentation we discussed a lot of 2020, like the following year. But what do you, if you have any, what do you think the 2020s as a decade may have in store for like employment-based immigration?
Well, I'm going to be hopeful because I like to be glass is half full. I would like to think that the Relief Act or something along those lines would actually be implemented because it makes logical sense, practical sense, and doesn't require for huge sweeping changes to how immigrant visas. I mean, it's a huge sweeping change, but it's not so drastic that it would call into question. It's very practical, and I think that we're going to kick off, particularly 2020, with practical and logical and pragmatic. And what can we do to help support? But there's just, there's not been a huge movement in immigration. I've been doing this for a while, and I would like to also see, solid support for DACA. Now, that's totally off topic for us, but, there's sort of a special place in my heart for dreamers, and those individuals who came to the United States without a choice, and this is their home, and unfortunately they weren't born here. And I would hope that there is just an increased sense that, and hopefully shift and absolute understanding that foreign nationals help contribute to our society, and have for a real long time. Historically speaking, since our inception. So, in my opinion, I think that it would be, I'm hopeful for the future that we really start across the board recognizing that, foreign nationals' contributions are good. Having that level of diversity is good for the United States as well. For schools, for classrooms, offices, just generally life. Having that level of diversity from that diversity standpoint is always a good thing. So I'm going to be hopeful.
Yours too. Yours too. We'll see. Awesome. Well, Sarah, thank you so much for the presentation today. As always, very informative, very insightful. To our attendees, thank you so much for joining us for today's webinar. And if you've watched a couple of them throughout the year, thank you so much for attending them throughout the year. As I mentioned at the top of the hour, everyone will receive the slide deck, the recording, and continuing education credits in a follow-up email tomorrow afternoon. Take care, and we'll see you in 2020.